It's time to turn to some of the specific actions of Amber Heard's team that have called their ethics into question. So we're going to look specifically at Amber Heard's counterclaim. And we're going to talk, of course, about the principles that we've been discussing, why lawyers need to behave the way they do, but we're going to also look at the specific rules that apply to these types of situations so that we can evaluate how are these decisions lining up. Let's take a look. Amber Heard filed her counterclaim in August of 2020 after 2 previous attempts to have Johnny Depp's complaint dismissed were denied. It was filed approximately 2 months after Elaine first appeared in the case for Amber Heard, replacing her former attorney, Roberta Kaplan. In Amber Heard's telling, Johnny Depp's complaint is part of a larger smear campaign that he orchestrated against her to punish her for coming out as a survivor of domestic violence. Let's look at some of the specific claims that she makes. She argues that Johnny Depp has orchestrated and coordinated an online smear campaign, including supporting and amplifying 2 Change.org petitions, one to remove her from Aquaman 2 and one to get her fired from L'Oreal. The Change.org petition has been very popular. At the time that I took this screenshot, not that long ago, it had over 4.5 million signatures. The petition was created and posted by an individual identified as Jean Larson. We'll get back to Jean in a minute. To carry out this goal of vengeance, according to Amber Heard, Johnny Depp controlled and coordinated and created social media accounts for the purpose of harassing Amber Heard online, for spreading false information about her, and to falsely sign these Change.org petitions to create the impression of more support than she believes they actually had. She identifies specific patterns that she believes these accounts demonstrate that indicate they are likely inauthentic, and she alleges that a significant number of the accounts that signed the Aquaman petition are conspicuously fake or highly suspicious. And she argues, therefore, that they reflect a concerted effort to create the false appearance of support for that petition. These accounts are plainly coordinated by Johnny Depp and Adam Waldman, according to Amber, for a couple of very obvious reasons. Number one, many of these accounts tweet positive things about Adam Waldman, the attorney who is publicly defending Johnny Depp on social media at this time. And horror of horrors, a number of these accounts are foreign language accounts, specifically even Cyrillic ones that might originate from Russia. And you know who has represented a Russian? Adam Waldman. According to Amber, 2 specific accounts that she names in her complaint are the main drivers of this disinformation campaign. But she also identifies several others that she claims are inauthentic, and according to her, investigation has revealed hundreds of other inauthentic accounts. These facts are what Amber Heard relied on to support count 3 of her counterclaim, which alleged that Johnny Depp violated the Virginia Computer Crimes Act, and that he did so by coordinating these social media accounts to conduct an online campaign against Amber Heard. Now, if this whole thing sounds a little bit conspiratorial and out there to you, you're not alone. And so you're probably wondering, are there any standards for what a lawyer has to verify before they go and make an accusation against somebody? Require them to come into court to actually answer this kind of nonsense? And so yes, there are, and we're going to look at 2 particular standards in the state of Virginia. The first requirement comes from the Virginia Rules of Professional Conduct, and it's Rule 3.1, dealing with meritorious claims. And it says very simply, a lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis for doing so that is not frivolous, which includes a good faith argument for the extension, modification, or reversal of existing law. What this means in a nutshell is that you have to have a factual basis and a legal basis to justify filing a claim against somebody. So what does that mean? Part of the problem you often have in a lawsuit is that you don't know what you're going to be able to prove until you get into discovery. You've already filed the complaint and now you have accesses to the investigative tools that you need to find the evidence that will either support or refute your account of events. So the rule has a comment that provides a little bit of clarification about how do we balance this tension between you need to have a factual basis to file a complaint, but we understand you're not going to have all of the evidence available necessarily at the time that you file. And so this comment clarifies the filing of an action or defense is not frivolous merely because the facts have not first been fully substantiated or because the lawyer expects to develop vital evidence only by discovery. Such action is not frivolous even though the lawyer believes that the client's position ultimately will not prevail. What these comments clarify is that it is not unethical to take a losing case. A lot of cases are not strong, but that doesn't mean that they have no basis. And so particularly in a situation where you may have an expectation of being able to uncover evidence to support your claim, that is a well-founded expectation, but for whatever reason, it doesn't pan out. The evidence has been lost. The evidence is not what you thought it was. A witness changes their version of events. Things like this happen all the time in the course of litigation that essentially limit your ability to prove your case and win it. So it's not unethical to lose a lawsuit, right? On pretty much any lawsuit, there's likely to be one side that loses. That in and of itself is not the problem. The problem is spelled out in this last comment here. The action is frivolous, however, if the client desires to have the action taken primarily for the purpose of harassing or maliciously injuring a person, or if the lawyer is unable to either make a good faith argument on the merits of the action taken, or to support the action taken by a good faith argument for an extension, modification, or reversal of existing law. Where you have a problem as a lawyer is if you're doing this for improper purposes, knowing that you don't have a justification to do it, or if you do it without the ability to justify it. You need to be able to substantiate, to support, to explain your reasons for why you think these allegations were justified. The second requirement that we're going to look at is from a Virginia statute. So this one is a little bit different because unlike the rules of professional conduct, the statute is not going to get you disbarred. It doesn't set that type of standard. But what it does is it provides the standard by which sanctions can be imposed for essentially misusing the legal system. And this is a requirement that is very common in many, if not most, jurisdictions. And it indicates that, number one, an attorney is required to sign a document before they can file it in court. So a signature must be on it. And then that signature represents certain things to the court. So in the state of Virginia, it represents three things. First, you've read it. You know what it is you're filing. Number two, to the best of your knowledge, Formed after reasonable inquiry, it is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. And 3, it is not done for any improper purpose, such as to harass or to impose costs of litigation on the other party. So you can see there's quite a lot of overlap between the language of the statute and the language of Rule 3.1, but there's one very important distinction here that I'm going to highlight, which is this language formed after reasonable inquiry. This language requires that attorneys do some investigation of the basis of their claims before they file them. They may not simply rely on the word of their client about what happened and how things went. They have to have some basis to support the conclusion that what the client is reporting is accurate and probably provable. So cases that have looked at this standard for imposing sanctions have identified as kind of the crux of the issue, what did the lawyer actually know? What did they know and when did they know it? If they did a reasonable inquiry before filing, but were simply mistaken about what the evidence would ultimately show, that is not a problem. That is not bad lawyering. What is bad lawyering is failing to take reasonable steps to verify what it is you're going to be alleging. So I found this particular case from Virginia that discusses it a little bit in the context of an attorney who filed an answer to a case that had been non-suited. And what that means in Virginia is that it had gone through basically the discovery process up to the point of trial and was then voluntarily dismissed to be revived at a later time. So the reason why that context is important is because a substantial amount of investigation had already occurred, and that attorney filing the answer should have known from that investigation what the evidence and facts were going to support. In this particular case, the court concluded there was no basis for these particular defenses that the attorney alleged based on that prior investigation. So an attorney would have knowledge when they asserted these particular claims that they weren't going to be able to justify them, that in fact the facts of the case did not support them. The second thing this case pointed out is that these 3 certifications that your signature on a document represents, you don't have to violate all 3 of them to get sanctioned. They are independent, standalone requirements. Any one of them justifies it. So if you don't read it before you file it, you can be sanctioned. If you don't do a reasonable inquiry and have a good faith belief in what you're going to be able to prove, you're going to be sanctioned. If you do this for an improper purpose, if your goal in filing this action is I'm going to cause this person some problems, that can be sanctioned. And in the case of Elaine Bredehoft in particular, we have reason to know that she's well aware of this pre-filing inquiry requirement because back in the 1990s, she was sanctioned by a court for filing a case without an adequate pre-filing investigation. She appealed it, and on appeal, that sanction was reversed. The court concluded that what she did was in fact adequate, and that because she had not signed the complaint, that she could not individually be sanctioned for the representations in that complaint in any event. In the facts of this particular case, Ms. Bredehoft was representing somebody who had been terminated. There was an allegation that the termination was for improper purposes. And so her pre-filing inquiry had included things like attempting to interview other employees and board members of the employer, the attorney firm that had done an investigation that led to his firing, hiring and basically tried to get some information to substantiate the allegation that it was wrongful. And so according to the DC Court of Appeals, which applies a similar pre-filing inquiry standard as Virginia, that was adequate. So with that in mind, let's go back to her counterclaim and let's start by looking at what is the law that has to be satisfied to establish a violation of the Virginia Computer Crimes Act. So that statute sets out that if you have intent to coerce, intimidate, or harass any person and use a computer or a computer network to communicate obscene, vulgar, profane, lewd, lascivious, or indecent language, or make any suggestion or proposal of an obscene nature, or threaten any illegal or immoral act, that's criminal, and it can also be enforced in a civil action. So if we go back to the facts that Amber Heard alleged to support this claim, you're probably noticing something pretty big is missing from her allegations. That would be suggestion or proposal of an obscene nature, threaten any illegal, immoral act, or communicate obscene, vulgar, profane, lewd, lascivious, or indecent language. She hasn't alleged any of that. Instead, she has argued that somebody exercised their First Amendment right to create a change.org petition, and that Johnny Depp allegedly, with Adam Waldman, employed inauthentic bot accounts to artificially inflate it and to say other mean things about her online. But that's not what the statute makes illegal. Very specific what is required here, and nothing in the allegations substantiates that. So that raises a pretty significant question of whether there is a good faith legal basis for her to be making this claim at all. But the second problem here is the one that is less obvious on the surface, unless you're automatically suspicious of these conspiratorial types of claims, which is what on earth is her basis for claiming that specific Twitter accounts are inauthentic, are bots? And what investigation did she do in order to substantiate that? Did she try to contact any of these accounts, DM them? Did she get some type of analysis done? Well, you know, part of the problem that Amber Heard has in substantiating her allegations that these accounts are fake is the fact that there was press back when Roberta Kaplan was still her attorney about an investigation that she hired Bot Sentinel, owned by Christopher Boozy, to perform into these accounts that were critical of Amber Heard. And according to that report, there were 13 active inauthentic accounts that they believed were specifically targeting Amber Heard, made for that purpose. So we can question whether the specific accounts that she has identified in her complaint are among these 13 active inauthentic accounts that she may have a reasonable basis to justify these allegations about. But that's not what she claimed in her complaint. She complained there were hundreds, and that appears to be contradicted by the public evidence that was available when she took this case over two months before from the previous attorney. Are we to believe that she had an entirely new investigation done that revealed a significantly larger number of bot accounts and yet did not publicly release this information like she did the previous time? I think we have a significant basis to question the factual underpinnings of her bot army claim. So as it turns out, the Virginia court in Fairfax agreed with me that there was not, in fact, an adequate factual or legal justification for these claims to be able to go forward. And so just a few months later, Judge White, who was in charge of the case at that time, issued a letter ruling dismissing count 3. So in his ruling, Judge White looked at her justification and found the allegation that he supported or amplified the change.org petitions doesn't imply anything suggesting that there was obscene language, threatened illegal or immoral acts, or any type of obscene proposal. Similarly, even if Johnny Depp did create, coordinate, control, and or manipulate social media accounts for the specific purpose of targeting Amber Heard, that doesn't meet the very specific requirements that the statute lays out. Now, Amber Heard has made so many comments claiming that she has been the victim of targeted hate and death threats and so forth on social media. And so it would have been extremely easy, if that were the case, to simply identify even a single one of them and put that in your complaint. Quote it for us, Amber. Tell us what this account had to say. And maybe you'll be able to get past that evidentiary hurdle of proving that it had anything whatsoever to do with Johnny. But it raises a really grave question in my mind about the reasonableness of what, if anything, Elaine did to confirm these allegations before she filed this complaint. Because a very simple step would have been, Amber, why don't you send me some copies of these texts, of these tweets, of these messages that you're receiving on these different online platforms so that I can quote them, so that I can rely on them and use them to substantiate this claim. The fact that she was unable to do so speaks volumes about what she knew and when she knew it. So based on this, in my view, we have a pretty reasonable basis for wondering if the requirement that Elaine conduct a reasonable pre-filing inquiry into the factual and legal justifications for her claims was satisfied. If it was not, filing this complaint was potentially sanctionable. But we haven't necessarily established any type of violation of the fundamental ethical rule, the 3.1 rule, that requires a good faith basis alone without this reasonable inquiry requirement. However, you'll remember that Rule 3.1 specifically identifies an improper purpose as a basis for finding a claim to be frivolous. So now we're going to turn to the evidence that suggests there may have been an improper purpose for this counterclaim to be filed. In the next video, we're going to take a look at the Twitter subpoenas. Join me there.